Welcome to the CCB series of the Copyright Alliance's Copyright Academy. In this series, the Copyright Alliance staff will take an in-depth look into the processes and procedures of the Copyright Claims Board, or as it's commonly known, the CCB for short. And the purpose of this is to help creators who are looking to understand more about the CCB. Now, hopefully you have already reviewed the educational materials on the CCB that are available both on our website and videos and FAQs we have. And then hopefully you've also watched our other Copyright Academy videos in the CCB series, especially the video on filing a claim with the CCB. If you have, then you should be generally familiar with the start of the CCB process and the names of the parties. But if you haven't watched those videos, then you may want to do that before watching this video because it's got a lot of helpful information. It'll help you better understand what we're going to talk about today. Today, we will be talking about what happens after the claimant successfully files a claim with the CCB. After the claim is successfully filed, the respondent needs to be notified about the claims so that they can understand the claims that are being brought against them, understand what the claim is, what the CCB is, and decide whether they want to participate or opt out of the proceedings. So today we'll be talking about that notification process. To speak on these issues, we have with us here today Kevin Madigan. Kevin is the Vice President of Legal Policy and Copyright Counsel at the Copyright Alliance. Kevin, let's start from the point the video on filing a claim ends. So after a claim is filed with the CCB, a copyright claims attorney will review it to make sure it is a permissible claim and otherwise complies with the CCB requirements. We talked all about that in that video on filing a claim. Now, at what point in the process does the claimant formally notify a respondent about the claim or claims that they have filed against them?
Claims filed with the CCB must be certified by a Copyright Claims Board attorney before they can be served on a respondent. And once a claim has been certified, the CCB will issue a document called the Notice of Compliance and Direction to Serve. Now, this document indicates that the claim has been approved and that the claimant can then serve notice on the respondent. The Notice of Compliance and Direction to Serve document also details what the claimant needs to do to serve respondents, which we're going to talk about a little bit more in just a minute.
All right, so you've used this word service and serve when discussing notification of the respondent. To make sure we don't lose anyone here as we go and talk about this a little bit more in more detail, what do the terms service and service of process actually mean?
Right. So service is the term used to explain the formal way a person is notified that a claim has been filed against them in a legal proceeding. The Due Process Clause of the Constitution requires that a person have proper notice of a legal action being taken against them. This is the case in all U.S. courts as well as the CCB. So the person being sued in court or at the CCB must be served certain documents, and those documents are collectively called process. And that's why serving the required documents is called service of process.
Excellent. Now, you just mentioned documents that must be included in the service of process. Can you explain a little bit more about this, like how many documents there are and how the claimant receives those documents?
Yes, so there are 3 documents that must be served on the respondent by the claimant. And the 3 documents will be packaged together and sent to a claimant by the CCB in something called a service packet. Now, the service packet is provided by the CCB in one PDF document, which claimants will receive in a separate email soon after the Notice of Compliance and Direction to Serve is issued. The 3 documents included in the one PDF in the service packet that the claimants will receive in the separate email are 1, the initial notice, 2, the approved claim along with any supplemental documents submitted with the claim, and 3, an opt-out notification form.
Great. So can you explain a little bit about what each of these documents are? I think people would like to hear a little bit more about what that all means, what those 3 documents are.
Sure. So the initial notice is a document that provides notice to the respondent or the respondents, if there are more than one, that a CCB claim has been filed against them, and it gives the respondents important information about the claimant, the claim, and the CCB itself. When the CCB creates the initial notice, it uses the information provided by the claimant in the filed claim. Now, the initial notice will be addressed to the respondent and contains essential information about the claim and the CCB, including things like the party's name, a docket number assigned by the CCB, the names and mailing addresses of all the claimants, the type of claim or claims that the claimant is asserting, and other information about the CCB and the proceeding. Now, the second document is the approved claim, which is a copy of the claim that the claimant filed with the ECCB and that the CCB attorneys found compliant. The claim details the facts that the claimant has described and the type of claim that the claimant is asserting, whether it be infringement, non-infringement, or misrepresentation. Now, lastly, the opt-out notification form is the document that the respondent who decides to opt out of the CCB proceeding may use to opt out by mail. A respondent may choose to opt out of the proceeding by filling out the opt-out notification either online or by mail by using the paper opt-out notification form.
Terrific. So let's talk about the various different elements of service of process. In essence, I want to cover the who, what, when, where, and how of service of process. Now, we just discussed the what is served. So let's move on to the when the respondent must be served. Can you discuss how much time the claimant has to serve all the respondents?
Yes, the claimant has 90 days from the day the notice of compliance and direction to serve was issued to serve the respondent. Then, once the respondent has been served, the claimant must upload proof of service to the ECCB within 7 days after the respondent has been served, but no later than 90 days from the day the notice of compliance and direction to serve was issued. So, for example, if a notice was served on the respondent 45 days from the day of the notice of compliance and direction to serve was issued, the claimant would have the full 7 days to upload proof of service to the CCB. However, if the notice was served on the respondent 90 days from the day the notice of compliance and direction to serve was issued, the claimant would have to upload the proof of service that same day. One last thing to note is that when a case involves multiple respondents, the 7-day window to upload proof of service applies to each respondent.
All right, so now let's move on to the who. Specifically, who serves the respondent? Is it the claimant, him or herself, who does that, or is it someone else who serves the respondent?
So claimants themselves never serve respondents. A respondent must be served by someone who is not a party in the proceeding and is at least 18 years of age. Most people use a professional process server that's located in the area where the respondent lives to serve the notice for them, because process servers should be familiar with the state laws and local practices concerning service of process.
All right, so we've discussed what documents must be served, how much time a claimant has to serve the respondent, and who can serve the respondent. What we haven't discussed yet is a really tough part, how a claimant actually completes service of process. So let's discuss that. Is there a simple rule? I hope so, but is there a simple rule for how to complete service of process that applies across the board?
Yeah, so unfortunately, there's not one rule for how service of process is completed. Instead, how service is completed will depend on numerous factors, including 1, where the respondent is located, 2, whether they are an individual or a business, and then 3, if they are a business, whether they have a registered designated service agent with the CCB.
All right, well, so much for an easy rule. So let's discuss each of these factors you just talked about. And let's take the last factor first. The last factor you mentioned was if the respondent is a business, you need to know whether they have registered a designated service agent with the CCB. So before we get into that part of it, maybe you can explain what a designated service agent is for the purposes of the CCB.
A designated service agent for purposes of the CCB is someone who is designated by a corporation a partnership, or an unincorporated association to receive service of process on their behalf. So, for example, a large company with multiple locations may want to designate a service agent to ensure that if they are sued by a claimant before the CCB, that the notice is not misdirected, since the claimant will know exactly who to serve process on. And to ensure that the claimant knows which organizations have designated service agents and how to contact those agents, the CCB maintains a directory of designated service agents called the Designated Service Agent Directory on the CCB website, which is publicly available and is provided to claimants. And I'd also note that it's the responsibility of the businesses to maintain up-to-date information in the Designated Service Agent Directory. That means information in the directory is assumed to be correct. And if a claimant serves process on a service agent listed for a respondent in the directory, service may be considered valid even if the agent information was incorrect because it was not updated by the respondent.
All right, so how does the claimant serve a business when that business has a designated service agent for the CCB?
Right, so if a respondent has a designated service agent for the CCB, the claimant is required to serve the agent named in the directory. Now, in most cases, the claimant must serve notice by certified or priority mail at the address listed in the directory. But in some instances, a claimant may have the option to serve a business entity by email if that business entity has notified the CCB that it will permit service on their designated agent by email. Now, keep in mind that if a claimant wants to serve such an agent by email, the same 3 documents we talked about earlier required by personal service must be included in the email. And the email should state that the claimant is serving the service agent in a CCB proceeding and identify the respondent. Now, you also keep in mind that if a respondent has a designated service agent for the CCB and that agent is not served or is served at the incorrect address, the service will be considered invalid. So, for example, if the claimant serves notice on an employee or representative of the company who is not the designated service agent, the service would be considered invalid. And basically what this means in practice is that any claimant who's bringing a claim against a business entity should check the publicly available designated service agent directory on the CCB website prior to serving notice to determine whether the business has a designated service agent. And then finally, if a claimant is using a process server, they should make sure the process server is aware of the requirements of the CCB and have them check the directory.
Okay, so your answer addresses a situation when a claimant wants to serve a business that has a designated service agent registered with the CCB. Now, let's discuss how the claimant serves a business when that business does not have a designated service agent with the CCB. Can you explain that a little bit?
When a business entity does not have a designated service agent listed in the CCB directory, the claimant may serve the business entity by serving an officer, a managing or general agent, or any other agent authorized by the law of the state where service is made to receive service of process, or by any other means permitted under the law of the state where service is made. Now, as a general rule, corporations and other businesses are required by state law to designate agents for service of process. And in many states, service may be made on that state's Secretary of State. So even if such business entity has not listed a service agent in the CCB's directory, it will have a designated agent under state law wherever it's licensed to do business, and the claimant may serve that agent under state law. Now, keep in mind that the agent for service of process under state law will not necessarily be the same person as an entity's agent listed in the CCB's designated service agent directory. So be sure to check the CCB's directory first. Now, I realize this can be a little bit confusing, so let me just try to summarize. If the business has a designated service agent registered in the CCB database, the claimant must serve the person or entity identified in the database and follow the CCB rules for how to serve that person or entity. But if the business does not have a designated agent registered in the CCB database, the claimant must abide by state law where the respondent business is licensed to do business. In most cases, that will involve serving the agent that the business has designated under state law. Now, one last very important point here I want to mention is that where there is no designated service agent in the CCB database and state law applies, The state law only applies to how the business is served, but does not impact all the things we discussed earlier, such as deadlines for service and the documents that must be served. Those are all determined by the CCB rules, not state law.
All right, so we've talked about businesses, two types. One, where they have a designated service agent that is registered with the CCB. One where they don't, and they probably have a designated agent that is registered with the state. But we haven't talked about individuals yet. So let's talk about individuals. What if the respondent is an individual? Can individuals designate service agents with the CCB?
No, individuals can't have designated service agents with the CCB. Only businesses can. And what this means is that state law will control how a claimant serves an individual. But as I just mentioned in our discussion of serving a business, state law only applies to how the individual is served. State law does not impact all the other things we discussed earlier, such as deadlines for service and the documents that must be served. Those are all determined by the CCB rules, not state law.
All right, so how does a claimant serve the respondent when the respondent is an individual and not a business then?
Right, so when the respondent is an individual, state law will control how to serve that person. Now, different states have different rules regarding how to serve someone, and so it's essential that claimants make sure that the person serving the respondent understands the local rules and complies with them. Now, that said, there are some commonalities. Personal service, which involves a qualified individual personally serving a respondent, is really the most commonly accepted form of service throughout all 50 states. Now, some states allow for anyone who is at least 18 years of age and not a party to the lawsuit to carry out service. But in other states, they require a law officer, like a sheriff or a marshal or a constable, or a private process server. Now, most states recommend the use of a private process server to carry out personal service because they specialize in service of process and they're familiar with the local rules. And while the cost of hiring a process server varies, the national average is somewhere between about $30 and $100, with expedited same-day service costing closer to $100. But private process servers are really easy to find. Many are listed in the local yellow pages or could just be found using simple online keyword searches. Now, service by mail is another option available in most states. However, the requirements vary by state. For example, some states require that a written request be filed with a clerk of the court before service of mail. Others require that service documents be sent via certified mail, while others require first-class mail and prepaid postage. Now, there are many online resources that list service requirements by state, including the website for the National Conference of State Legislatures, which is ncsl.org.
So since serving an individual is going to depend on largely the state that they're in, maybe you can give an example or two of the service rules for different states to give some people an idea of kind of what they're dealing with here.
Sure, so let's take a look at the rules for a couple states that have large creator communities and are the home to many creative industries, New York and California. So in New York, personal service can be carried out by anyone 18 or older who is not a party to the case, including private process servers. New York also has something called substituted service, which is a two-step process involving one, delivering the papers to a person of suitable age and discretion at the actual place of business, dwelling place, or residence of the person to be served, and then two, mailing the papers by first-class mail to the person to be served at his or her last known residence or mailing them to his or her actual place of business. And just note that such delivery and mailing need to be made within 20 days of each other. Now, New York also allows for delivery of service papers to an agent of the person or business being served. And finally, New York has an option called nail and mail, which requires one, affixing the papers to the door of either the actual place of business, dwelling place, or usual place of abode within the state of the person to be served. And then number two, either mailing the papers to the person to be served at his or her last known residence or by mailing them by first-class mail to the person's actual place of business. Then, like New York, California allows personal service on a respondent if the individual serving the documents is not a party to the case and is at least 18 years old. In California, service by mail is also allowed. However, the person mailing the documents cannot be a party to the case and must use first-class mail. unless it's for a small claim in which certified mail is acceptable. California also allows for substituted service, which requires the server to fill out a declaration of due diligence if personal or mail service was unsuccessful. And finally, California, like most states, allows for service of a designated agent when serving a corporation. And just to wrap up, I'd say that these are very general overviews of the rules of these states, and we encourage everyone considering serving a respondent in a case before the CCB to review the rules applicable to the relevant state.
All right, Kevin, you've done an excellent job of simplifying what are very complex rules for how to serve a business or an individual. But, this is pretty complicated stuff. Some claimants may still be confused. Do you have any additional suggestions or comments that you want to add on about the service of process?
Sure. So because, as we discussed earlier, a claimant cannot accomplish service themselves, they're going to need someone else to do it for them. If claimants consider that, along with the fact that the rules can get a little confusing in cases where the respondent is not a business that has a designated agent with the CCB, it's probably prudent to do as many states recommend and just hire a process server to take care of serving process. It's a relatively affordable process, and it involves experts who know the exact rules.
So you would think we pretty much covered the whole terrain here, but we haven't. There's actually one last fact pattern we haven't discussed yet. And that's the case where the claimant does not know the identity or address of the respondent. How does a claimant serve someone when they do not know the identity or the address of the respondent? For example, the claimant may not know the identity of the respondent. The respondent is an anonymous user who's posted some infringing material on the internet, perhaps. So how does that all work where the person basically either their identity and or address is unknown?
Right. So claimants can use something known as a subpoena to determine the identity and address of a respondent. Now, a subpoena is a written order that can be used to compel a party to provide information on a particular subject. Now, Section 512H of the Digital Millennium Copyright Act, also known as the DMCA for short, allows a copyright owner or their representative to request the clerk of a court to issue a subpoena to a service provider to identify an online infringer who's using that service provider's platform for the infringement.
All right, so how does this DMCA subpoena work? Can you explain that a little bit?
Okay, so Section 512H of the DMCA provides that a copyright owner can learn the identity of an alleged infringer through a federal court-issued subpoena sent to a service provider. The first step is that the claimant must send a DMCA takedown notice to a service provider requesting that the provider remove or disable access to the infringing content. That takedown notice should include a lot of different information, including the notice sender or claimant's contact information, the location where the infringing content can be found, a description of the copyrighted work, a statement made in good faith confirming that the use of the work is not authorized, and a statement that the information in the notice is accurate and, under penalty of perjury, that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly being infringed. The claimant must then submit a subpoena request to a clerk in a U.S. District Court. Now, the subpoena request must include three different things. One, a copy of the DMCA takedown notice. Two, a proposed subpoena. Three, a sworn declaration that the identity of the alleged infringer will only be used for the purpose of enforcing the claimant's copyright. The clerk will then review the subpoena request, and if the notice and draft subpoena are in proper form and the declaration is executed correctly, the clerk will issue the subpoena and send it to the claimant. Now, once the claimant receives the issued subpoena, the claimant then sends the subpoena to the service provider. The service provider is then required by law to disclose the identity of the alleged infringer to the claimant. Once that information is disclosed, the claimant should hopefully have enough information to serve the respondent. Now, I realize that's a lot of information and steps, but the CCB should be providing additional educational information about subpoenas on their website in the near future.
So our entire discussion has been about serving the respondent. Are there any exceptions to the service requirements, or does the claimant always, in every instance, have to serve process on the respondent?
Yes, there's one instance where the claimant does not need to serve process on the respondent. That occurs when the respondent waives service of process. Claimants can ask a respondent to waive service of process by mailing them a completed request to waive service form and the waiver of service form that are included in the service packet documents that will be provided to the CCB that we talked about at the beginning. The request to waive service form and the waiver of service forms can be found by signing into the ECCB and going to the docket for that claim. All of this information and step-by-step instructions are provided in the Notice of Compliance document and the Service of Claims section of the CCB handbook. Now, if a respondent agrees to waive service by signing the form, the claimant does not need to formally serve process on the respondent. However, if a respondent waives service by returning the signed waiver form to the claimant must upload the form within 7 days after the form was received from the respondent, and no later than 90 days from the day the Notice of Compliance and direction to serve was issued. Now, it's important for claimants to understand that waiver of service does not mean that the respondent has agreed to participate in the proceedings. It simply means that the respondent agrees to accept process without being served according to the formal rules for service of process. A respondent may choose to waive service because they don't feel the need to make the claimant serve them formally, or if they do not opt out, waiving service gives the respondent an extra 30 days to respond to a claim after the proceeding has become active. And a respondent who waives service still has the ability to opt out. Another thing to keep in mind is that requesting a respondent to waive service does not extend a claimant's 90-day window for filing proof of service on the respondent. If a claimant wants to request the respondent to waive service, they should make that request soon after receiving notice that the claim is compliant to ensure that they still have plenty of time to serve process and file proof of service if the respondent decides not to waive service.
Okay, so we're toward the end here of our discussion of notification. We have covered a lot of territory. So last question of the day, what is this second notice we've heard about? It's in the law, it's in the regulations. Is this second notice, is it something the claimant serves on the respondent? I mean, what exactly is a second notice?
Yes, so in addition to the notification that claimants send to the respondent when they're served, the CCB will send a separate notification within the 60-day window if the respondent has not yet opted out. Now, the purpose of the second notice is to make absolutely sure respondents have received a copy of the claim, notification of the opt-out period, and other important information that they understand everything. The CCB will not send the second notice until it has received proof of service or proof of waiver of service from the claimant. Now, to be clear, there's nothing for the claimants to do here. The CCB sends the second notice, not the claimant. One last point to note is that the initial notice from the claimant starts the 60-day opt-out period, not the second notice from the CCB.
All right, well, thanks, Kevin. We've covered a lot of ground here. Hopefully, after watching this video, claimants will have a better idea what they need to do in order to notify the respondent about the claim they have filed with the CCB. But in the event you're watching this video, you still have a lot of questions, unanswered questions maybe, you can go to the Copyright Alliance's CCB Explained page, which is on our website, or call our CCB hotline, which is 888-5403-CCB. Once again, that's 888-5403-CCB, and you can get more information that way as well. And of course, you can always check out the numerous resources that the Copyright Office provides on its website at ccb.gov. So thank you again for watching this video. Please keep an eye out for future videos about the CCB process that we'll be doing as we continue to try to educate people about the CCB. So thank you for tuning in and listening to our latest video on notifying respondents about the claims that have been filed against them.